Hello guys, welcome to my tutorial classes. Now before I begin with my lectures, if you haven't subscribed to my channel, I would request you to kindly subscribe it, like it and then share it. Now let's go to today's topic. So you can see on the board, today's topic is Workmen or Employee Compensation Act 1923. Now, why have I mentioned these two things? Let me explain you first of all. So, when the Act was first formed, its name was Workmen Compensation Act 1923. Alright. Then down the line, in 2009, its name was changed to Employee Compensation Act. I'm going a bit fast, but then I will be talking about these two in the next slide. But then, just to give you a glimpse because it's in the first heading, right? So, why employee? So, they have replaced this workman with employee, so that, like you see here, it's not there, but to make it gender neutral, right? First thing, and secondly, these things, it covers more like a number of workers. Out here, like when it means like workmen, it matters to only like some particular workmen in a manufacturing plant and all those. So we will be speaking today like who are employee and what is compensation and how to get, who gives, what not, basically. Alright, in like simple lucid language, I'll be explaining to you. And I will not be going in depth. That is like there are a number of sections, so I could not like make it to number of sections, right? It's like a matter of like constraint of time and everything. Like there are various contingencies. So let's begin. I hope you are at least clear like why it's workman and employee. So from now on, like after 2009, that is from 2010, its name is changed to Employee Compensation Amendment Act 2009. Alright? And also it was amended again on 2017, that is 2017. I'll be like speaking about it too, but then let's have a glimpse first. So for the better understanding, what like I have arranged it in a simple format. Like I have given a quick facts. So what does it say? Just a glance, like even if you read this whole sentences, you'll get to know what the act is all about. So let's go. Quick facts. Came into force on July 1, 1924. See, this Workmen Compensation Act 1923, or rather I would say Employee Compensation Act 1923, it came into force when? July 1, 1924, right? And applicability, it's whole of India, including Jammu and Kashmir. And this act, it has 36 sections and 4 schedules. And also it has 4 chapters, alright? Now, Employee Compensation Act, Amendment Act 2009, December 22, it was passed, right? And it came into force on 18 January 2010. Like I'm a bit confused with the date. In some book I have found as 9th January. So please confirm it once. I'm so sorry. Now what does it say? See, now before like going in details, like I just want to say this chapter, let's say this act, like Employee Compensation Act 1923, it doesn't mean that it is only necessary for HR students or HR professionals or the employer. Alright, these days, the world is a small, it's a small place, right? So you need to know lots of things. For example, let's say I am an employee. If I am an employer, of course I need to know it. If I am an employee, what are my rights? Yes or no? I will get to know what are the compensation, how much I will be paid. So this is very in general, it's not necessary that you have to be an HR student or what. For example, like, see, let's take a small example of like applying PAN card or passport, or say filing ITR, or PAN card. Like, for example, let's say those who are in remote areas, they won't be like knowing how to apply online, right? Even if you are in urban areas, there are many people who won't be knowing how to apply even this passport. So what do? We have to visit these agency shops and then pay some extra money and then apply for it. Yes or no? Same thing like filing ITR. So what's the point? Same case goes with this employee compensation. I'm not saying like it's everything is like related, but what I'm trying to say is like in today's world, you have to know each and everything. So it's not necessary that you have to be an HR or a HR student or one who is like gonna appear for exams. It's not necessary. Like even for like at least try to know what the heading is all about, right? It's good to know. For example, RTI Act 2005, Right to Information. So these things are like what to say? It's so like common that you should know. Sometimes let's say you are going somewhere, there is a discussion. You will be sitting inside otherwise. So for that purpose, at least I will appreciate like if everyone try to know like what this act talk about. Like it might so happen like from your own family, like some might be working in a factory. So at least you will get to say, Dad, I have come to know that this or this. Yes or no? So let's go. Now, see, employee compensation, alright? So where we over? Now, this line says, it provides compensation to workmen and their dependent. Workmen and their dependent. In case of injury and accident, mind it, there should be an injury, there should be an accident. This accident should cause an injury arising out of and in the course of employment. Out of employment. That means what? This accident should be, there should be some relationship with employment and accident. Yes or no? Or else there should be an injury. Of course, without injury, you won't be getting any compensation. For example, let's say like I got an accident, and let's say my accident was like nothing like harmed me. Of course, like I got a cut here, and then it did not decrease my earning capacity. Will I be paid compensation? No. So these are the things why you should know what it talks about, this act. Basically, I'll be explaining. So, out of employment, and one more thing, in the course of. So basically it talk about time period. Now, out of employment, there should be a relationship between this accident, injury and this employment, right? The first point is gone. You're very clear already, like it provides compensation to workmen and their dependent only in case of injury and accident. Accident and injury should be there, but then this accident should be out of employment and in the course of employment. That means out of employment means there should be some relation with employment. It's not like you went somewhere and you got accident. No. That's not like you are not gonna be paid any compensation, alright? In the course of employment time period. So when does the employment time period starts? Let's say you go to office at 6 a.m. You enter, your like time period starts, and you get out at let's say then 6 p.m. So up to this period it talks about. Alright? Now what happens, like sometimes company they provide you some buses or transport. So the moment you get inside the transport and then reach, that time also will be counted, irrespective of your working period gets over. Alright? So these are some points you should keep in mind. and we'll be discussing some cases too. So I guess all of you are clear. This is the short information regarding this act. So let's go in detail now. Now, yeah, I also told you that there are 4 schedules, right? See, Schedule 1, list of injuries. What are those injuries that shall be called permanent total disablement? And now I will be speaking after this what is like disablement. What is called disablement? So part 2. So Schedule 1 has 2 parts. That is part 1. Part 1 talks about what? Permanent total disablement, and part 2 talks about permanent partial disablement. Permanent total, in a sense, let's say a man lost during accident or injury both hands. This is what? Like I had to cut down 2 of my hands. So I'm what? No more use. I can't earn anymore. Yes or no? Yes. So that is what? Permanent. It's permanent, right? And it's what? Total. Everything. Like I can't even earn. I don't have any more capacity to earn. So that's called permanent total disablement. Alright. Now what is permanent partial disablement? Permanent is like permanently losing. So let's say I lose 1 toes or this thumb, or let's say these 3 fingers. So this will be what? Permanently I have lost, but it will be partial. It might decrease my earning capacity, but it's not that I will completely be unable to earn. Yes or no? So keep in mind. Now Schedule 2, it talks about list of persons who shall be included in the definition of workman. So try to go here one by one. I haven't inserted here, but then you should, for your knowledge purpose, visit those at least the internet and try to see what are the Schedule 1, 2. Alright. Now Schedule 3, list of occupational diseases. For example, when you work in a factory, let's say mining factory or cement factory, or let's say explosive, where there are explosive or chemicals factory, what happens? There are working condition. Of course they will try to maintain very good, but then there are some it might so happen that due to those chemical exposure and whatnot, you may contract some diseases. So what are those diseases which comes under this occupational disease? It is given in Schedule 3. Alright, I hope everyone is clear. Now Schedule 4. Schedule 4, it talks about relevant factor. It is lump sum equivalent of compensation. So what this relevant factor do? While calculating this, let's say your compensation. Let's say I'm an employer and I will try to find out how much I should pay you with respect to permanent total disablement or permanent partial disablement, right? So that time this relevant factor is being used, and it is calculated on the basis of age, and you will be provided this. It is there. You can see any level loss book, and I haven't put anything in here, that you will get used to it. So there's nothing much to explain about it. And during exam also you will be given questions, you along with the questions you will be given relevant factor. So there's no point in explaining much, right? And for the exam purpose, this is very, 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 very important. For example, UGC NET might ask you what does Schedule 2 of Workmen Compensation or Employee Compensation Act 1923 speaks about. So you should know what are they. So at least try to memorize or try to understand too, and try to read what are some of the diseases. Sometimes it so happens that they may ask pneumonia does it fall under occupational diseases or not? So you have to go and at least see in brief, if something eye-catching things, because you never know what the examiner might ask you in exam, right? And it's all about cracking exam. So you have to gonna prepare the questions in such a way that you're gonna leave even one. So be very sure of knowing at least those schedules. So you may note down, pause a video and note down. It's very important. Alright? So going back to next Now, see, of course, I have already entered into the act, but then these were some of the defenses available before this, like why this act came into force. So, see, before this 1923 Employees Compensation Act, workers had lots of like defenses. They were like, they can like exploit, or they can like give any excuses of not paying compensation. So what are those? We'll be speaking about them, and because of all those things, this Compensation Act was enacted. Alright? So basically, say defenses available to employers. It was before passing these acts. So these were the defenses that employers they use like in order to avoid themselves to pay the compensation. So what are those defenses, or say they are, yeah, let's say defenses only. I don't even get the other term. So one, what is, you can see in the board, it's doctrine of assumed risks, and it is known as violenti non fit injuria. It's a Latin word. What does it say? See, violenti, I guess it's voluntarily you have like assumed to take risks. So what does this doctrine tries to tell? Say a worker, let's say me, like an employer, when he asks me to like do some work, okay, I know that there is risks with it, and I know something might happen, and I know that the risks gonna affect me. I already like assume that there will be risks. I know, like I have a knowledge that there will be risks, but then I accepted his order, let's say, and then I have worked, and in times it so happened that I was like I came across accident and I got injured, let's say. So this time employer will say, no, you can't get any compensation. Why? It's because you knew that if you do this work, you will get like accident. You know that there are risks, but still you did voluntarily. So I am not the one to be blamed, it's you to be blamed. Just see, the logic is so simple for them. Wow, I was like surprised when I read. And I read a case about this, like I don't know if I have written here or not, like just give me a second. Yes. To like know more about this, try to read this Morris versus Murray. Morris versus Murray, 1990. AIIER 801. So it's with respect to like which I have told, like here there is one the story. Let me tell you the story actually. Let me better tell you the story, otherwise I will also get confused. You are also going to get confused. So this Morris versus Murray case, what does this case talks about? See, there was two guys. Yes, these two only. Let's say but A and B. Okay, with respect to this story. So A is a pilot, right? And this is passenger. They were drunk. So B, what he did? A, he like what to say? He was a passenger of his aircraft. All right. So, and the pilot was drunk. Even he was drunk. All right. But he helped the pilot to reach the aircraft and start the engine, and they flew off. But what happened? You know, when a drunken drive, and it goes where? Directly to accident. So same case happened. The pilot died on the spot and he was injured. Now he want to sue his real estate man, the owner of this pilot, I mean the aircraft. So there was a case, and the case said that he will not be paid any compensation. Why? Because he said that he was drunk, so it was not my will. Okay, this B. But the court said, if you were not on your will, then how could you help the pilot to reach the aircraft. You knew that he was drunk, so you helped him. There was some consent from within you. Assume this voluntarily. So he wasn't paid any compensation. Try to read more, you will understand. So this is what it talks about, doctrine of assumed risks, right? You already knew, you can assume. You voluntarily did this, so you cannot get no compensation. Alright? Second, doctrine of common employment. Now, common employment in the sense, let's say we are a group of employees and we are working, alright? So what the employer will say, it was not done by me, it was done by fellow worker. Or let's say like when I am like another worker we work, and it so happened like he might something slip over me and I got injured. So what the employer will say, it was not me, it was done by the co-worker. Common employment. He blame game. So I guess this is also done. We'll go a bit faster, right? Sometimes when I like this is thing I liked it, so I keep on speaking. It's very bad actually. So now, doctrine of contributory negligence. Now, what does it say here? It says that the negligence is being caused because of the employee. Alright? Here like this employee, he tries to say that, let's say A got accident. But the employer will say, no, it's his negligence. How can he do such things? He should know. He will try to blame him. It was done because of his negligence, not mine. All those. They keep on blaming, and what? They do not pay compensation. Isn't that too harsh? Yes or no? Now third. End of personal action with death. That means what? This doctrine tells that as soon as the person dies, all the his personal action also dies. No one can be blamed. Right? See, extra personal is moratorium, calm person. Sometimes it's so asks like voluntary non-fit injury means what? Or they will give a theme of that this doctrine, and sometimes they will give this line and explain. So Morigo, I used to say in Assam is Morigo. So end of or death. Just some line and try to remember. So here they say that worker is gone, then what is the use? Everything dies along with him. His like right to compensation, everything also. See, here also again they try to avoid in this way. So these are the few things which were too harsh towards the employee. It's very difficult for them even to get right compensation. Yes or no? So due to this, government has tried to overcome, and they have passed different laws. And what are they? Fatal Accident Act 1855, and they also passed Employers Liability Act 1938, and then Employee Compensation Act 1923. And this is how Employee Compensation Act 1923 gained its importance, and it is said it is one of the best social security legislation. Alright, okay, I forgot one more thing. We have discussed this even in our first lecture. Employee Compensation Act. What type of legislation it is? And it is social security, right? And it is enacted by central and enforced by both state and central, I suppose. Try to go back to the first slide or the video lecture, then you will come to know. So try to link everything. Actually, you know what? This type of laws or labor laws or industrial relation, there is a linking somewhere or the other. Some part or no, there is lineage is there. Of course, there is an ocean here, but the tributaries, rivers, it comes flowing, right? Something like that. Try to link up, then you will get more understanding. I understand I might not be that clear to make you understand, but then I'll be trying out my level best. I hope you people at least understand what I have told till here. So this is how Employee Compensation Act 1923 emerged, right? Now ways to claim compensation for employees. okay, for the employees. So what it says here? Now, I, employee, or anyone, you, me, anyone, it might be anyone. So let's say we got an accident, or there was an injury, or there was an injury. It should be physical, psychological, whatever, and due to accident. So now what? There are two options. One, you can get a compensation with respect to this compensation act, alright? You can get a compensation. And second, you can file a suit against the employer. But if you file this, you're not going to get any compensation. And again, one more thing, filing a suit to employer against employer, if you're giving case, there is no point, because you're not going to win any employer. It will take long years, or the case might not be solved too. It might be. So it's better take compensation. And why this compensation is being provided? So you don't have to go to the court of law and everybody has to come down the line, take discussion, again extend it. So this compensation is in short how much you are liable to get, or how much the employer is liable to pay, you will be paid, and it's close. Alright. So it makes everything a bit easier, feasibility easier. So this is. So if you file a suit, you cannot get compensation. Alright, either of the two, you have to choose one. So going back to the next slide, here it starts now actually, chapter. There are 4 chapters. It is chapter 1 talks about preliminary. It means the starting basically about the act title and its definitions. What are the different definitions? Alright. And second, it will be compensation, and third, it talks about chapter 3 talks about commissioners, who is commissioner and whatnot. And chapter 4 it talks about rules, and we're not gonna deal in chapter 4. I guess till chapter 3 I'll be touching, and then I'll wind up. Okay. So in section 1, what does it talk about? Short title, extent, commencement. Everywhere in the act, this one will be the starting one. At least you try to see once and try to check it out. You will know. So what does short title means? Title is what? Employee Compensation Act 1923. Where does it extend? Whole of India. Commencement when? 1 July 1924. See, we have done. Then definition. So what are those definitions important definitions I have selected basically? So commissioner. So the commissioner appointed by state or central, I forgot, just check it out. With respect to this act is known as commissioner. Now who is eligible to be commissioner? I'll be speaking about this in the next slide. Commissioner, and section D, 2D, it's dependent. Now who is a dependent? A worker. Right. And it's dependent. There are numerous dependent, and it took me 1 page to write it down, and I can't even memorize it now. But then let me give you a brief idea. So it will be his wife, minor child, unmarried daughter. Again, if wholly dependent, pura dependent, then it will be what? Child means his son or daughter. Who is minor means they are dependent. Again, even if not minor, they will be paid compensation. They will be called as dependent, but he or she should be infirm. That means mentally or physically not well. Alright. And then his parents, and if no parents, then grandparents, and also predeceased son. There are a lot more. Try to read. Dependent is also very important, and I can't remember as a whole so many, seriously speaking. And sometimes I let it go during my time. What I do, 2 months is gone and I give exam for 98 marks. 98%, I mean, sorry. 98, its total was that time more than, this time it's 200. So I'll be appearing exam for 198. So do not follow this, but just go in there. Try to read out from the act. It's given in the X. Alright. Now section 2 FF talks about minor. Minor means below 18 years of age. And section 2M wages. So it includes everything which can be expressed in terms of money, but it excludes house rent allowance, right? Then PF, gratuity, disablement. Now you can see the board. Disablement consists of how many? Two types, right? Partial and total disablement. All right. Partial means it is some part, and total means as a whole. Let's say this is one person. Partial means, total means, let's say he is unable to move at all. Partial, he can still move, right? The concept, just take it in that way, alright? So, disablement, what does disablement mean? It refers to injury causing loss of capacity to work or move. That means, let's say I was earning 100 rupees, right? Let's say, and after my injury, that is after an accident, let's say it was partial disablement. Okay, my earning capacity was 120 rupees. Now how much do I earn? I earn rupees 50. That means, am I like completely unable to work? No, that's why it's known as partial, right? Now same case. Now I am like, I got an accident, and this time like I can even move, neither I can work. So now my earning capacity is zero. That means I get 0 rupees. So what is it? It's total disablement. Alright. So the logic is very simple. Try to get it in this. Okay. Or else, sorry. Or else you can either say, now what is total, you know? What is partial, you know? And this partial, it has two things. One is temporary partial and permanent partial. So temporary partial, okay? Temporary partial in a sense, let's say a crack in a hand, like you are unable to walk. But it talks only with respect to present industry. Okay. Reducing in the capacity of like earning capacity. Okay. Loss of earning capacity with respect to only present employee, not like to other employments. Only where you are working at a time of injury. Okay, this is very important note. Try to read the definition, you will get. See the definition, I will be reading out for you. It means reduction in earning capacity of employee in present employment in which he is engaged at the time of injury. Alright? So you are only in the present employment. Alright? Now, permanent partial disablement, what it says? It means reduction in earning capacity of employee in every employment which he was capable of undertaking at that time of injury. Permanent talks of every establishment or every employment. Let's say he was working at A, like let's say he lost these 4 fingers, or let's say he lost a thumb. It's like permanent, right? Can you get back another like thumb or fingers? No, you can't. No matter what, it's like permanent, but it's partial. It's not that I can't move, neither I can work. I can still work, though my working capacity may reduce. So irrespective of wherever I go, like today I'm working here, tomorrow if I go there also I'll be the same, right? Yes or no? So it talks about every establishment, and it is permanent in nature, right? So I hope you guys understood the difference between this temporary. Temporary means, you know, for a short time, or it may be for few days, and permanent, it's permanent throughout your life. So I hope you understood. Now going back to the next slide. Now what's an employee? Like I said, employee is a railway servant, crew of ship and aircraft, driver, cleaner, mechanic of motor vehicle. It's clearly like written here, you don't have to be explained. Employed by contract labor, and also it includes employees recruited abroad, like those who work outside.